Please be seated. Council, please approach for a moment. Let me know when you're ready to bring the. Let me know when you're ready to bring the jury back in. Okay, thank you. State ready?
Yes, ma'am.
Please bring the jury back in. Please be seated. Mr. O'Mara, call your next witness, please.
Defense will call Tracy Martin, Your Honor.
Do solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may proceed.
Good afternoon, sir.
Good afternoon.
State your name, please.
Tracy Benjamin Martin.
And, of course, you're Trayvon Martin's father.
Yes,
You've been here for the testimony throughout the trial, correct?
correct.
Including today when we had a couple of officers testifying about an event where you had gone to meet with investigator Chris Serino at Sanford Police Department.
Correct.
Remember that?
Yes,
Do you remember the event itself, having gone down there? I believe you went with Brandy Green.
yes.
Okay. Did you have a conversation with Officer Serino about why he wanted you down at the station?
Yeah, initially, we were going down to the police department to make sure that he had verified that Trayvon had been identified. Detective Serino didn't bring me to the station. I actually went to the station myself.
Okay. With Miss Green?
Correct.
And at some point, you did go back to his sort of office cubicle area and listen to some tapes, is that correct?
Correct.
My understanding is, from my knowledge of the discovery, was that you listened to a number of tapes, one of which was the tape that we're identifying as the Lauer 911 call, correct?
Yes.
And he did play that for you?
Yes.
And were you listening to it as he played it for you?
Yes.
Understand that it was difficult to listen to. It included the shot that ended your son's life, correct?
Yes.
At the end of that tape, do you recall Officer Serino asking you whether or not you could identify your son's voice?
Not those exact words, but something to that nature, yes.
Okay. Do you recall the words as best you can recall that he used?
As best as I recall, after he played the tape, he basically just said, "Do you recognize the voice?"
And what was your response?
My response was just simply, I didn't tell him that I didn't know. I didn't tell him, no, that wasn't Trayvon. I think the chairs had wheels on them, and I kind of pushed away from the table and just kind of shook my head and said, I can't tell.
So your words were, I can't tell.
Something to that effect, but I never said, no, that wasn't my son's voice.
You heard Officer Serino testify that you said no, correct?
Correct.
And you heard Officer Singleton also testify that she was about 8 or 10 feet, and she heard you say no, or an indication that you acknowledged it was not Trayvon's voice. Is that correct?
Before Officer Singleton even testified, the first time Officer Singleton testified, that was the first time I ever seen her. I had no idea that she was even in the vicinity.
Right, you didn't notice her there, correct?
No.
But you heard her testify that she heard you, correct?
Yes, I heard her testify.
As you were here today.
I heard her testify to that, but I didn't see her in the room.
Okay. Did you ever say to anyone, did you ever ask to hear the tape a second time?
Not at that moment, no.
Did you ever tell anybody that you had listened to a cleaned up version of the tape and were then able to identify the voice on it?
What do you mean cleaned up version?
I'm asking you, sir.
To my knowledge, the tape that I listened to is the same tape that's circulating. That's the only tape I know of. I have no knowledge of a cleaned up version.
Okay. So the question then is, did you ever tell anybody, your attorney or anybody else?
I never told anyone that I listened to a cleaned up version of the tape.
Okay. Or an enhanced version?
I have no knowledge of an enhanced version.
Did you ever tell Sabrina Fulton, your ex-wife, that you had listened to the tape at Officer Serino's desk?
I hadn't told her, no.
Was there any reason why you didn't give her that information?
There was a lot of stuff going on. We had just buried our son. A lot of emotions, and you just don't think of every little detail that you've been through. It was a tragic and still is a tragic time for us. So just to answer your question, did I tell Ms. Fulton that I listened to the tape? No, I didn't. Now,
you were at the mayor's office when the tape was played for the entire family, correct?
Correct.
And you were there as well, listening to the tape?
Yes.
Did you ever take an opportunity to tell Ms. Fulton or any of the other family members before the tape was played what they were going to hear?
No, I didn't.
Is there any reason why you didn't advise them of that?
I'm sure they were aware of what we were doing at the mayor's office, so there was no reason for me to confirm, in fact, that we were there to listen to the tapes.
And was it at that time in the room with everybody else? What did you say about the tape when you listened to it that time in the mayor's office?
What do you mean, what did I say?
Did you acknowledge anything about the tape to anybody?
After listening to the tape for maybe 20 times, I said I knew that it was Trayvon's voice. I didn't direct that towards any family members. Matter of fact, I think the family members had started leaving out the room. It was too much for them. They couldn't take it. And I just decided to sit there and listen to it.
Had you listened to the tape between the time that Officer Serino played it for you on about the 28th of February and about the 16th of March when you heard it in the mayor's office?
No, listened to it in Detective Serino's cubicle and then again in the mayor's office.
Okay, no time in between?
No.
Okay. Have a moment, Your Honor? Thank you, Your Honor.
Thank you, Cross.
Mr. Martin, even at this time, is it hard for you to believe that your son is not longer living?
It's very difficult to believe that Trayvon's not living.
Okay.
As I said over and over, that was my best friend in life, and to have him gone is tragic.
Okay. You were asked two areas that I want to cover with you that Mr. O'Mara asked you about. The 911 call that you heard, or the calls, the recordings that you heard at SPD, or Sanford Police Department. You remember going there?
Yes.
Now, in terms of this jury understanding the context, that your son was killed late evening Sunday, February 26th. And you would have gone over to the Sanford Police Department the morning of the 28th. Do you recall that?
Yes.
And I believe also you really found out your son was dead at some point after the 27th. Is that true? That
Correct.
Monday?
Yes.
Okay. And was it still hard for you to believe that your son was dead?
It's still hard to this day that he's dead.
Okay. And officers had come to your house, I believe, on the 27th and told you that your son was dead, right? First, they wanted to verify that that was your son, in terms because he didn't have a ID with him, so they wanted for you to verify that he was the person that they found out in the courtyard of that retreat at Twin Lakes where Brandy Green lived, right?
Correct.
Okay. And I gather you went and got a picture of your son just to show them who your son was, or did they show you a picture of the person that at that time was just described as an unknown person out of the courtyard? They showed you a picture of a body there on the ground, correct?
Check, Your Honor. May we approach?
Yes.
All right, proceed, Your Honor.
Yes, you may.
Mr. Martin, I was asking you about the 27th. Detective Serino, or Investigator Serino, had come and showed you a photograph. Is that correct? And you identified it as being your son, correct?
Correct.
Okay. Now we move to the 28th, where they asked you to go down to the police station, correct?
Correct.
And you go down with your fiance at the time, Brandy Green, correct?
Correct.
Okay. And at that time, they played several recordings to you, correct?
Yeah, they played a series of the 911 calls.
Okay. And these were calls where neighbors had called in regarding what you now knew was the death of your son, correct?
Correct.
Right. And the recordings were of people calling and explaining that somebody had been shot, and I'm sure you listened to the person now identified as Ms. Gordyka, the lady who went hysterical in the 911 call. You were listening through all that, is what I'm saying.
To my recollection, I don't think Detective Serino played each call in its entirety.
Okay.
He played some of the, to my knowledge, he played some of each call leading up to the last call with the fatal shot.
All right. So they played the call then of the cries for help, and then you actually hear a shot. Is that correct?
Correct.
Okay. And am I safe to assume that you still at that time were in denial in the sense of not wanting to believe that your son was dead?
Correct.
Okay. And this was an emotional time for you. Would that be fair to say?
Very emotional.
I must object and refer to the
Then give
court's-
me your,
your previous ruling.
okay, we're now on to the day of the phone calls being played overruled.
This was a very emotional time for you while this was going on. In terms of, I'm talking about the day the recording was played for you at the Sanford Police Department, correct?
Correct.
Okay. And you listened to the recording, and as you stated, described to the jury, you pulled your chair back in disbelief that you were actually listening to voices for help, and also, more importantly, also a shot.
Correct.
You realized that that was the shot.
That killed my son, yes.
Did you really know what to do at that point?
No, my world was from that point until today, my world has just been turned upside down.
Okay. And let's focus on that day. Then, after you heard the cries for help, or the recording that's been referred to as the Lauer recording, and then also the shot, at that same time, or right there, Investigator Serino asked you about the recording, if you could recognize the voice, correct?
Correct.
Okay. And I'm assuming that was difficult for you to even contemplate identifying or not identifying the voice. Is that correct?
Correct.
Okay. And as best you could, you attempted to answer Investigator Serino. Is that true?
Yes.
Okay. Now, as was pointed out, there was a lot of commotion in that recording, wasn't there? The yells for help, the person calling, and then most importantly, the shot, too. How, in terms of your mind, what was going through your mind, can you describe through your jury what was going through your mind when you were listening to that?
Basically, what I was listening to, I was listening to my son's last cry for help. I was listening to his life being taken, and I was trying to come to grips that Trayvon was here no more. It was just tough.
And as Mr. O'Mara pointed out, subsequent time you were present when that recording was played again at the mayor's office. Is that correct?
Correct.
Okay. And I believe your former wife, Ms. Fulton, was present, correct?
Correct.
Okay. And I think you said you wanted to listen to it. Did you listen to that recording and then other recordings at that time too?
I can't remember. I can't remember if it was all of the 911 calls or was it just that last 911 call. But I do remember that I took whole control of the mouse or the clicker or whatever it was that they had, and I was able to rewind that same tape over and over again.
Did you want to, I guess, hear your son's voice over and over? Did that bring you any comfort, I guess, is what I'm trying to ask.
Object again. Same relevancy objection as before. The court ruled on.
Overruled.
May I have the question read back for some further argument? There's
No, I'll be glad to rephrase the question.
Okay, thank you.
You were playing that recording over and over. You were still dealing with this?
Yes,
His death?
Yes.
Now, it was sometime in March. It was later. It wasn't like days later. You were still having to deal with his death?
Correct.
Okay. And you played it, you said, did you actually write down 1, 2, 3, 4, 5, or you're estimating you played it at least 20 times?
I'm estimating that I played it maybe 20 times.
Okay. And you played it over and over. Why? Were you trying to deal with this, or why were you doing that?
Wasn't as much as I was trying to deal with it. I was just trying to figure out on the night of February 26, 2012, why did the defendant get out of his vehicle and chase my son?
And you weren't there when it happened, correct?
Correct.
And this recording, I guess, is one of the last things in terms of hearing the voice and the shot. You were trying to, as best you can, figure out what happened or why it happened.
Yes.
Thank you, sir. No further questions.
Can you redirect?
Yes. Do you believe that the police lied when the two officers said that you said no about it being your son?
Objection, Your Honor, is improper about what somebody else is saying.
Foundation question for another one, Your Honor. I think it's necessary.
Well, you have to rephrase your question because it's not proper to have a witness comment on another witness.
I'll do it this way then. Did you ever instruct your attorney, Ben Crump? You didn't have Ben Crump when you listened to the tape on the 27th, or the 28th, did you?
No.
He was not your attorney at that point?
No, it wasn't.
Later, did you instruct him to say that the police lied when they said that you couldn't tell, when they said that you had said no about it being your son's voice? Did you instruct your lawyer to say that?
I never instructed anyone to say anything.
You never instructed Ben Crump to say that the police had lied about that?
I never instructed anyone to say anything.
Did you instruct your lawyer, Ben Crump, to say that the audio has since been cleared up and now you can hear it better?
No, I didn't.
Nothing further. Your Honor.
Thank you. May Mr. Martin be excused?
Yes, Your Honor. Subject to recall, obviously.
Okay, Mr. O'Mara, may Mr. Martin step down?
Certainly.
Okay, thank you, sir. You may step down. Call your next witness, please.
Chief Bill Lee, Your Honor.
Okay.
Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, I do.
You may inquire.
Thank you, Your Honor. Afternoon, sir. State your name, please.
My name is Billy Ray Lee, Jr.
And on February 26, 2012, what was your occupation?
I was the chief of police for the city of Sanford.
No longer in that position?
No, sir.
When did that end?
June 22nd, 2013. 2012, I'm sorry.
Thank you. Were you then chief of police during the initial investigation stages of the case that brings us here today, State versus George Zimmerman?
Yes, sir.
If you would just tell the jury a little bit about your background in law enforcement.
I have 30 years of law enforcement experience. I started at the Seminole County Sheriff's Office as a road patrol deputy in 1982. I was promoted through the ranks to the position of captain. I retired in 2009 at that rank of captain in charge of our Special Operations Division and Emergency Services Division. 9 years of that experience was in investigations, 5 years as an investigator, 4 as a supervisor.
And where'd you grow up?
I was born and raised in Sanford.
It's your hometown?
Yes, sir.
Did becoming chief of Sanford Police Department then be sort of a pinnacle in your career for its law enforcement?
Yes, it was.
How long were you with Sanford PD as its chief?
I'm sorry,
How long were you with Sanford PD as its chief?
from May of 2011 to June of 2012.
Did you say that you came out of retirement in order to take that position?
I retired from the Seminole County Sheriff's Office and took a position with Seminole State College as their director of the Center for Public Safety. We provided training, certificate training in the areas of law enforcement, corrections, firefighting, and paramedic and EMT services, and also a 2-year degree program in each of those disciplines.
And were you then sort of recruited from that teaching position to get reactivated in law enforcement as the chief of Sanford PD?
That position came available while I was still at the Sheriff's Office, and I applied for that.
Particular to this case then, I presume that you were you hands-on or were you just in a supervisory role over the investigation with the George Zimmerman case?
I was in a supervisory or administrative role at the police department.
But did you have particular focus on this case as well as time went on from February 26th during the time that you still had involvement in the case?
Yes, sir.
Okay. Did that also include the playing of a 911 call for the Martin family members? Were you aware of that decision? And I want to focus you at this point, simply were you aware that that decision had been made, that the tape was going to be played for the Martin family?
My recommendation was that the 911...
I want to be careful a little bit. That's why I focused the question. I don't want to spend a lot of time dealing with the decision to play the tape. I want to focus once that decision was made, we'll talk about then that point forward. So you are aware, were you not, that a decision was made that the tape would be released to be played to the Martin family. Is that
Yes.
correct? Okay. Once that decision had been made, I want to focus you on the way that the recording was played for the Martin family, okay?
Yes, sir.
So, generally speaking, with your experience in law enforcement, within the context of what we will call lineups, or whether that be a visual lineup or an audio lineup, what are the best practices as to how to handle lineups generally?
Generally, just as in, for example, a photo lineup, you would show that photo array or that piece of evidence to a potential witness in a case individually.
Okay. And what is the purpose of doing it individually rather than in a group?
So their decision is not influenced.
One from the other? One witness influencing another witness?
Yes, sir.
So if, in fact, you were showing, as an example, a photo lineup to this jury and asked if they could pick out me, would you do it as a group, as a jury, or would you do it individually, one juror at a time?
You should do it individually.
And the purpose of doing it individually as opposed to a group?
So their identification would not be influenced by others.
Is that a similar process then to what would be done with an audio lineup?
Should be, yes, sir.
And an audio lineup, similar to a photo lineup, is just having somebody listen to a piece of evidence to see if they can identify anything in that piece of evidence?
Yes, sir.
And that was what was going to happen in this case once the decision was made to play to the Martin family, correct? That it was going to be played for them?
It was my understanding that one member of their family had already listened to that tape. You know, again, my recommendation.
Right. We're going to talk. I want to talk about your recommendation as to anything other than once the decision was made. What was your recommendation as to how the tape should be played for the family members?
It should be played individually.
Do you know the result of how it was played? Was it played individually or as a group?
It's my understanding it was played in a group setting in the mayor's office.
Was law enforcement present?
No, sir.
In your years of experience, how is that normally an event that would be handled by law enforcement?
Yes, sir.
May I have a moment, Your Honor? In this particular case, then, did you ask to be present during the time that the recording was to be played by for the family?
I offered to be present. Yes, sir.
And was that accepted?
No, sir.
Were you excluded from the room?
Yes, sir.
Nothing further, Your Honor.
Thank you. Cross?
Good afternoon, sir.
Good afternoon.
The mayor made a decision not to have you in there, is that correct?
I believe I asked the city manager if he wanted me to be in the
Right.
room, and they declined to have me.
City manager was your boss?
That's correct, yes, sir.
And so is the mayor, I'm assuming, too, by virtue of that? Or?
In my position, my contract was with the city manager.
Okay, all right. And the recording itself was played in the mayor's office, correct?
Yes, sir, that's correct.
And you weren't, I apologize, did I interrupt you?
No.
Did you finish answering?
I did.
Okay, thank you. And you were not present when the recording was played, correct?
I was not present in the mayor's office.
I
no,
think
sir.
you were in the same building, but not in the mayor's office when it was played.
That's correct.
Did I have that right?
Yes, sir.
Okay. Now, you were asked about the lineup, and just so the jury knows, in case they haven't heard of a lineup, what you're talking about is you don't want to have a suggestive. In other words, you don't want to have, normally a lineup includes 6 photographs, right?
Yes, sir.
And you have a person look at the lineup and then identify if they know one of the individuals that did something to them or was a witness or whatever. Is that correct?
That's correct.
Okay. And what you don't want to do is show them a photograph, just one by itself, correct?
That's correct.
Okay. Now, also, in a lineup, you don't want a potential witness to a crime to have seen something on TV saying, this is the person, in this case is about this, and here's a photograph. You don't want to do that either, correct?
Preferably not. Yes,
Right?
sir.
Because that would be kind of tainting it, correct?
Correct.
So, in other words, if your experience, you had case and the witness said, oh, I saw the photograph on TV or I heard the voice on TV and it was, they broadcasted regarding the case of Joe. Joe was a suspect. That would be tainted, correct?
Possibly.
Okay. And the reason is because then the person potentially was influenced by the fact that the case dealt with Joe, and they knew Joe was arrested, and there's a photograph of Joe, then that would be tainted, potentially, correct?
Possibly, yes, sir.
Okay. And that also would apply to voice, correct?
Yes, sir.
Okay. I mean, voice and photo lineups, you kind of do the same thing, correct?
If you can, yes, sir.
Right. And when you say a voice lineup, you would actually have 6 separate recordings, to be fair in terms of completely accurate. You would have 6 separate voices, and you would have the person actually listen to all 6, and then say, if you did it similar to a photo lineup, you would have a person then say, which one do you recognize, correct?
If you could have 6
Right.
audio recordings that were similar in nature, and when you prepare a lineup, there's supposed to be certain characteristics of that person that is the subject of that photo lineup that is similar to all the other photographs in the photo array.
Right. Just like if you had a photo array, you wouldn't pick if the suspect had a beard, you wouldn't put one person with a beard and the other people without beards, correct?
That's correct, sir.
Because that would be suggestive, correct?
That's correct.
Okay. Now, and so the jury understands, so in other words, you don't want somebody potentially making a decision based on what they've seen on TV of the photograph or the voice ID versus actually listening to it without having watched anything on TV about the case.
Yes, sir.
Okay. Thank you very much, sir.
Thank you.
May we read?
Please, just so we're clear on this case, the issue of who was screaming for help on the tape was still an issue that you, as the agency investigating the case, was looking into, correct?
We had, the evidence and testimony that we had gave us an indication of whose voice it was screaming for help on the tape, but any other witnesses that we could try to corroborate that would be beneficial in trying to find the truth.
And the indications that you had from the other evidence was that it was George
Objection,
Zimmerman's
hearsay.
voice.
Beyond scope.
Beyond the scope sustained.
But as to the tape itself and playing it for other witnesses, the potential witnesses are the Martin family themselves, were they not?
Yes, sir.
Okay. And Mr. DeLeon suggested that you go out and get 6 voices, but the reality in this case was that you would have done it in a way where each Martin family member would have listened to it themselves and come up with their own opinion as to who they heard, correct?
Objection, Mr. Levy.
Overruled.
That means you can answer.
Can you ask the question again?
Sure. Within the confines of this case, is the best practice in this case, would the best practice have been to allow, once the decision was made, to have them listen to the tape? Would the best police practices have suggested that you let each family member listen to it individually and get their statement as to what they heard?
If it was for investigative purposes, to let the person that was going to listen to it individually, so that you could get their response without influence.
And that you would avoid the influence of having them all listen to it at one time, correct?
Yes, sir.
And would you agree that in an emotional circumstance such as this one would be, that the possibility for influence is even greater?
It's possible, yes, sir.
Now, you had said that it was the city manager, in response to a question by Mr. Delarianda. The city manager doesn't normally make police decisions, does he?
No, sir.
Does he go out and fight fires?
No, sir.
Leaves that to the fire department?
Yes, sir.
Leaves police work to the police department?
Yes, sir.
Thank you. Nothing further.
Thank you. May Mr. Lee be excused?
Yes, I don't have any further questions.
Thank you.
Okay, thank you very much. You're excused.
We had discussed that this might be a good time to end for the day, and I would ask for that.
Ladies and gentlemen, although you might think that it's early to go for the day, which is 4:27, we have some matters that we do have to take care of outside your presence. So instead of keeping you back in the jury room, I'm going to excuse you for the evening. During the evening recess, you're not to read or listen to any radio, television, or newspaper reports about the case. You're not to discuss the case amongst yourselves or with anybody else. You're not to use any type of an electronic device to get on the internet to do independent research about the case, people, places, things, or terminology. And you're not to read or create any emails, text messages, Twitters, tweets, or blogs or social networking pages about the case. Do I have your assurances that you will abide by these instructions? Yes. Okay, with that, put your notes face down, follow Deputy Jarvis back, and have a good evening. Okay, please be seated. From my notes, I had 5 different things that were, or actually 6 matters that we were going to take up at this time. One of them is the state's motion to strike Mr. Donnelly's testimony and have a Richardson hearing on that. There's the state's motion in limine regarding toxicology, the animation, and Mr. Root. And then there was the state's motion to strike testimony from Officer Serino and Officer Singleton. In light of the fact that Mr. Martin has testified, is the state still moving to strike that testimony?
No, Your Honor.
Okay, then those are two things that are off the plate. So that leaves the Richardson hearing regarding Donnelly, toxicology, animation, and Mr. Root. Is there a preference from either side as to how you want to take those up?
I would imagine the Richardson inquiry would be the most direct and probably the easiest, Your Honor.
Okay, let's go ahead and begin with that.
Are you asking for my response? I know the state has
Right.
made some argument.
The state's argument for the record was that the allegation was that the defense had a knowledge prior to Mr. Donnelly testifying that he was going to identify Mr. Zimmerman's voice on the 911 tape, and that at the time of his deposition back in May of 2013, I believe it was May, he did not indicate that he had listened to the tape or had an opinion as to the identification of the voice. And his testimony here today was that he listened to the tape this past Saturday, which was July 6th, and spoke with Mr. O'Mara that afternoon, and that information had not been revealed to the state. So the Richardson hearing is to determine whether or not that was a discovery violation, number one, and number two, what prejudice it is to the state.
And I don't know.
Am I correct in my recitation?
Yes, Your Honor.
Okay, thank you.
Yes, Your Honor. The only thing, if I could, I would add that it's not like there was no opportunity to communicate that information. As the court knows, yesterday, counsel spent several hours together taking a deposition of another witness. And I will say, too, I haven't been able to verify it yet, but there have been some individuals who've indicated that Mr. Donnelly may have actually been present in the courtroom at some point last week during part of this trial. Again, I don't have a confirmation on that, but...
Okay, well, that's not part of the Richardson
Understand.
hearing. That would be another issue.
Yes, Your Honor. And so, for the record, his deposition was middle of page 14, and the question was, have you listened to any of the 911 calls? Answer, I do not believe so. No, sir. Question, so you have not formed an opinion about who uttered whatever was uttered? Answer, no, sir. And that is the material change, and I've provided the court 3 cases, and I believe that as far as the prejudice goes, the cases outline those, and I can go into that further or give Mr. O'Mara a turn. I'm happy to do that as well.
Well, the question is going to be the prejudice. I mean, I think that Mr. O'Mara acknowledges that that information was not provided to the state yesterday or before Mr. Donnelly testified today. So the prejudice issue is what would happen, or what would the state have done differently had you known that information?
Well, I think the first case that I provided, Your Honor, and the issue, I guess, is procedural prejudice. And, of course, the cases that I have to rely on are cases where the defense has accused the state of doing the same thing. But in any event, the Scipio case, that's SCIPIO 928 Southern 2nd 1138 from the Supreme Court of Florida, it's going to be on page 9 of the court's copy. I guess begins on page 8. But there they discuss the sort of things that could have been done, procedurally speaking. In this scenario, if the defense attorney had known about the recantation or the change in testimony, the defense could have sought a continuance since the medical investigator's testimony was critical to the defense's case, or the defense could have chosen not to call the witness to avoid the surprise. It is even possible the defense would have chosen to call and impeach the witness to present the jury with his prior inconsistent testimony. Although that would appear to have been highly unlikely. What is certain is that the misconduct directly prevented the defense from considering these options and instead forced the defense. Again, so there would be any one of a number of things. For example, had this information been communicated, we could have more thoroughly investigated the background and the reasons for the witness doing that, as opposed to having to try to do it rather tactfully in front of the jury. In other words, who suggested that you do it? What did you do? When did you listen to it? What did you listen to it on? Who else was around? When did you communicate this? Why did you do it? And those sorts of things that are very uncomfortable sorts of questions to be confronting a witness in court. Number two, the foundation for his background could have been more fully explored. Number three, it may have been a scenario where we would have said, Judge, we need additional time to, again, investigate the issue of whether he'd been in court or whether he had watched any of the proceedings to know whether or not this is something he should do. The reason, in other words, for his decision that he claimed was on his own. And then finally, Your Honor, there would have been simply the opportunity to point out that apparently this witness did, for whatever his purpose had been, something that he knew was designed deliberately to go ahead and assist the defense. And he communicated this change in his testimony not to anyone other than counsel for Mr. Zimmerman. So there would have been any number of possible procedural avenues the state could have taken, at least at a minimum, to postpone the questioning that had to take place in front of the jury until that issue could be more fully explored in a deposition setting. That is, after all, the reason we take depositions in the first place and the reason questions like that get asked.
Okay. Let me ask you a question.
Yes, Your Honor.
If he never listened to the tape on Saturday, and he came in here to testify, the tape was played for him the first time here in court, and he indicated that he knew that that was Mr. Zimmerman's, what would be the difference?
The difference would be that that is I think, a very risky scenario for any to do. But I guess the other reason, the other difference is...
Well, that would have been a risky scenario for the defense.
Yes.
And he wouldn't be changing his testimony. It would just be now he's being played the tape, whereas at his deposition in May, he said he had not listened to the tape. So if he's played the tape the first time in the courtroom...
If he's played the tape the first time in the courtroom, he can then be confronted about, again, the foundation.
Well, I guess my question is going to be, what is the state... if that were to happen, what would the state have done differently? So I understand that you say that his background, but that's something the state could have explored, and his background isn't an issue. It has nothing to do with his identification. Well, the state's being able to explore his background has nothing to do with whether or not he listened to the tape. I don't have the full deposition in front of me, and I don't know whether his background questions were asked. So really, what the issue is, the fact that he now listened to the tape, he identified Mr. Zimmerman's voice as the person on the tape, and the defense knew that Saturday afternoon. What would the state have done differently?
I guess that is somewhat addressed in the next case that I gave, Your Honor, and that's Evans. When we're talking about the scenario that we're talking about here, and I'm sorry, that also in Casika, that's C-A-S-I-K-A, which is the third case. In the Evans case, the court made clear that in situations like this, what really is it's tantamount to never listing the witness at all when you've got such a radical change in opinion. And because of that, the question becomes whether there was a material hindrance to the preparation or strategy of the approaching the witness. I understand the court's question is exactly what that would have been. And the Casika case sort of goes into this. An analysis of the procedural prejudice considers how the defense might have responded had it known about the undisclosed piece of evidence and contemplates the possibility that the defense could have acted to counter the harmful effects of the discovery violation. It is immaterial whether the discovery violation would have made a difference to the fact finder in arriving at the verdict. So because there are a number of different approaches and certainly a number of different ways to react to present that information to the jury, the state was procedurally prejudiced by having it, if it were done, as Your Honor points out, sort of in open court like that, then the opportunity becomes present for the state to say, wait a minute, you're telling us that you've never heard this before, but you can walk in right away and instantly know that, having never, again, heard this person under those sort of circumstances before. Whereas when one side knows exactly what that witness is going to say, it becomes far more easy to ask those questions. If the other side doesn't know what the witness is going to say about it and doesn't know because that information was deliberately withheld, it hampers the ability to artfully frame that sort of cross-examination. That's the procedural prejudice that the Supreme Court and the appellate courts have recognized before, and that is the prejudice that I'm attempting to articulate now.
Okay, thank you. Mr.
First of
O'Meara?
all, Your Honor, it has to be material, and I'm not certain that an addition of testimony that wasn't apparent and existing at the time of the deposition and was found out later is, in fact, material to begin with.
Are you saying that his identification of Mr. Zimmerman's voice on the tape is not material?
No, it definitely is material. It's material evidence for the jury to consider. But what I'm saying is they had an opportunity to have him play him the tape back in his deposition. They asked him if he had. They could easily have done it back then, and for whatever tactical reason, knowing them to be good prosecutors, they decided not to ask him of that. And quite honestly, nor did I. However, under Scipio and other cases, you have to look at the effect that it has. So, if in fact I had called them up at 5 or 6 o'clock on Saturday and said, by the way, just heard from a witness, here it is, what would they have done different? That's really their prejudice. I think you were trying to get to it from the opposite side of the timeline. What if he just did it right here? What's your prejudice? So if the state says, if we had known Saturday night, we would have done all this enormous amount of work, let them present that to you to see if that's true and indeed prejudice. I find it almost incredible that we're here on the fact that a witness listened to a tape a couple of days ago and now testified to it in the light of the discovery violations that we've addressed or failed to address in this court for the past year, not the least of which is the Steve Brenton pending discovery violation that leads us to our next motion, which is going to be attempting to figure out how to deal with.
Let's stick on this motion, please.
Okay, as to this motion, I think the state has failed to show any prejudice in the fact that Mr. Donnelly took it upon himself, and, as is now under oath, did not do it at request of counsel, listened to the tape, and melded that into his testimony. And if, in fact, the state needs, if they lost 36 hours of effort and they want another 36 hours, then maybe they can address it back with the court on Wednesday if there's something that they accomplished then that they couldn't accomplish now. I thought their cross-examination, Mr. Donnelly, was quite good and got to the point of why he listened to it, when he listened to it, and quite honestly did everything else that they would have done had they had the additional 36 hours. I guess 6 or 8 of which we were in deposition, so now we're down to 30, take away sleeping, and maybe there was 20 hours or so they could have done work on Mr. Donnelly. But if they need that time, I think you can give them that. Let's not forget that under Richardson, the courts are obligated to utilize the least restrictive means, if you will, to address any Richardson violation. It's got to be a substantive violation, it's got to be material, and then the remedy is the least amount of remedy which is necessary to address the issue. Certainly, striking a witness's testimony would be the last thing at the far end of the spectrum, and you start at the beginning end of the spectrum, not start at the end.
Respectfully, Your Honor, there are 2 types of violations, willful and inadvertent. When there is a willful violation over and above the least restrictive remedy, the court has the power to penalize that willful violation. I haven't heard that it's anything but that yet. The other matter is, in terms of having more time to prepare, the question isn't, do we need more time now? The question would have been, this is a matter that would have been, reopen the deposition, ask these questions, get this background, instead of having to do it on the fly with the jury sitting there and the court here and trying to proceed in trial with that going on. The time and place and manner to explore all that background and do that is not necessarily in front of the jury because, frankly, it does tend to, if the witness is a sympathetic civilian, create a perception problem. And that's the reason that the defense takes their depositions when they do. It's the reason the state takes their depositions when they do. You don't want to create that impression to the jury that you're somehow attacking or accusing when you don't know the answer to the question. So you have to be much more reluctant. You have to ask questions differently and different questions. That's what had to happen here today. It didn't have to happen here today.
Okay, I misspoke when I said I didn't have the deposition because counsel had given it to me and I found it here on the desk. So I have the transcript here in front of me, and I've been reviewing it, and nowhere in here does anybody ask him what his prior military experience was, and it was the state taking the deposition. So you're coming into court now and saying we didn't have that opportunity. You did have the opportunity at the time of his deposition to ask about his background and go into that. And you may not have known that it was relevant to what his testimony would be today, but the court wanted to correct itself that had not been done. I do find that the defense should have and did not provide that information to the state, but I also find that the state has not shown this court the prejudice that's necessary in order to strike the testimony. So that's the court's ruling on the Richardson hearing. Now we have the toxicology, the animation, and Mr. Root. Which one do you want to go for next? Is the state ready to do that one? Does anybody have a copy of the toxicology report so I can look at it?
I have it on my laptop.
The toxicology consists solely of the lab work that was done that finds 1.5 nanograms per milliliter of active THC in Mr. Martin's blood, and I think it was 7.2 nanograms per milliliter of the metabolite. That's the hard evidence of the use of marijuana that's at issue. We have that provided to the court, but that's all the toxicology revealed that's at issue at this time.
I would like to see a copy if somebody has it. Okay, thank you. Yes, please, thank you. No, I just wanted to be able to look at it while we're having the argument.
Relevant part, I think, Your Honor, is in the box. It's in the box.
Okay, thank you. First page?
Yes, in the top. There's a box in the center that has the results.
Okay, yeah. This is the state's motion in limine, so who's going to be arguing for the state?
I'll handle it for the state.
Okay, are you ready to proceed?
Judge, I am. As we previously handled this before trial, and I cited for the court the case of Edwards and Arias, and I would rely on those again. Because the defendant did not know Trayvon Martin and did not have any idea about his state and the fact that the levels of marijuana discovered at the autopsy were so minimal, we feel like it is unduly prejudicial for the defense to now try to bring that in, as in without any showing that it would have had an impact and what the impact would have been on Trayvon Martin, and also, of course, that the defendant had no knowledge of it. So therefore, we submit to the court that its probative value is near zero and its prejudicial value is very great. So we would ask you to remain with your opinion in ruling that it should be excluded.
Okay, just so the record is clear as to where the state, where we are on that issue, the pre-trial motion in limine that was heard by the court, I made a ruling that the toxicology report and the results would not be mentioned by either side in the opening statement, and the court reserved as to the admissibility of that report or a testimony regarding it to the time of trial. So that's where we are. Okay? Who's arguing on behalf of the defense?
Your Honor, in the motion in limine that was filed that the court addressed just this moment regarding opening statements, the focus of the argument was based upon the Diaz case and then ultimately the Arias case, and that is that simply to ask a medical examiner on cross-examination if there was toxicology related to the deceased blood would not in and of itself be admissible. There had to be an issue in the case to which it related, specifically self-defense. We are clearly at the point in this case where self-defense is the issue. It's indeed the focus of the entire case. We know that there is a positive level for THC in Mr. Martin's system. We know that even under Dr. Bowles' testimony, that while he may have at one point said it would have no effect, he changed his testimony. That was the subject of a proffer yesterday, or last Friday, I guess, and then the subject of his notes that the court looked at. That now his testimony would be that, yes, there was sufficient THC in Mr. Martin's system, that it would have some effect, maybe somewhat difficult to quantify, but that it would have some effect on his thinking. We know from George Zimmerman's non-emergency call that he said Trayvon Martin, the person he didn't know that he later found out was who he was describing, looks like he's on drugs or something. We also know from looking at the 7-Eleven video that Mr. Martin is swaying at the counter, which I think is consistent with what Mr. Zimmerman later saw. We also know from the evidence that Mr. Martin is carrying a lighter. We know as well that I'll proffer that we have testimony that we'll offer through our expert witness that the level of THC in Mr. Martin's system is sufficient to cause some level of impairment. And that because of that, and because of Mr. Zimmerman's observations of Mr. Martin's behavior, the fact that Mr. Martin indeed was under the influence of drugs at the time is highly relevant and probative for the jury. And I think under the holdings of both Diaz and Arias, it absolutely is admissible, that it supports our claim of self-defense, that now, because Mr. Martin's behavior is also at issue, because self-defense has been raised, that the evidence of his level of toxicology and the testimony as to how that may have impacted on his behavior is highly probative for the jury. We also know, in addition to that, of course, that the state in its motion originally said that there's no evidence to suggest that Mr. Martin ingested the marijuana at or even near the time of death. We know that's not quite right either, because Dr. Bao suggested that he would have ingested it relatively recently without putting a particular time frame on it. We know from Dr. Goldberger's deposition, that's the state's toxicologist, that the ingestion would have been fairly recent. He couldn't say if it was 2 hours or 4 hours, but if he were an occasional user, it would have been within the last few hours prior to his contact with George Zimmerman. In fact, Dr. Goldberger cited to the research of Dr. Marilyn Eustace that we talked about originally in our response to the state's motion. I can take a look, if the court doesn't have a copy of Arias handy, I'm happy to provide a copy of it. But the language in Arias, which references Diaz, is compelling and exactly on point for why this evidence is now admissible, even though it may not have been until the subject of self-defense was raised. May I provide a copy, or does the court...
Please. No, I don't have a copy of that case. Thank you. Did you, State, have a copy?
Is that Arias?
Yes.
I do.
Thank you.
The language, it's not a long case anyway, but the legal discussion is head note 2, the numbered paragraph 2. I will read that a homicide defendant is afforded wide latitude in the introduction of evidence supporting his self-defense theory, where there is even the slightest evidence of an overt act by the victim which may be reasonably regarded as placing the accused apparently in imminent danger of losing his life or sustaining great bodily harm. All doubts as to the admissibility of evidence bearing on his theory of self-defense must be resolved in favor of the accused. The toxicology evidence comes in because it is relevant evidence and not under any theory of admissibility of character evidence, referring to 90.404. Again, area cites to Diaz, which talks about the precise objection the state made in its earlier motion, but we're well past that now.
Okay. I read it.
I have a copy of Diaz as well.
I have Diaz. Any response?
Please. Judge, again, it's not just that there is a substance present. There has to be an effect, and it can't just be some effect or there may be an effect. There needs to be some concrete testimony or evidence about the exact level and what that impact would have on this person, in this case, Trayvon Martin. We don't have that in this case. In the Arias case, and I believe it's Arias, in that case it was admitted because there was a .21 blood alcohol level, traces of cocaine, and cocaine metabolites. That's obviously something where a person, an expert, can testify as to the effects that the amount of those substances would have on a person. In this case, we just don't know. We don't know if it brought him up, brought him down, affected his behavior in any way. And as to the defendant's comment that he must be on drugs or he may be on drugs, he also said a lot of other things about Trayvon Martin that weren't true. So I don't know that we can take the defendant's observation. If the court needs to see the 7-Eleven video again, I'd ask the court to review it. The defense says they're swaying. I submit to the court he went in there without any trouble, paid for his drink and candy, and left without any incident. So again, I think they're trying to backdoor some very negative character evidence on a fact that there's a presence of a substance in a system that no one has come before this court and told us what the impact would be and how that would have affected his ability to be either more aggressive or less aggressive or better able to defend himself or not as capable of defending himself. So just to have it out there in front of the jury without some sort of testimony about the effect that it would have had is of no value.
Well, I think that's what they're trying to do through their expert that they're going to come in and testify is to not only the levels in the toxicology report, but what effect that would have.
I understand that's what he said, but I haven't heard that. And I think the court would need to hear that in a proffer before you could make a sound decision on whether or not the probative value outweighs the prejudicial effect.
No, and of course, the state would have the opportunity to cross-examine the witness and to call any rebuttal witnesses if they choose to do so. So when are you expecting the witness to come in and testify?
Likely at some point tomorrow.
Okay, so we'd have an opportunity to proffer that portion of its testimony without going into all the background so I can hear what, because my reading of the Arias case, and there's another case of McBean, that's spelled MC capital B-E-A-N, and that's at 688 Southern 2nd, 383. It's a 1997 case from the 4th DCA. Really stands for the same thing that Arias does, that to not allow that testimony to come in would be reversible error. And that was also a homicide case. And they proffered testimonies to the effects of cocaine ingestion on the behavior of the decedent and stated ordinarily a toxicologist is not competent to testify on the behavioral effects of cocaine ingestion, but they found that The trial court erred in finding that this toxicologist was not qualified to testify and basically keeping that testimony out. So I don't even know what the proper testimony would be that would change the rulings in these cases. And like I said, the state has the opportunity to cross-examine this witness, and will also have the opportunity to call a rebuttal witness if they so choose. So I'm going to deny the motion in limine and allow the testimony. If there's an objection during the course of the testimony, I'll rule upon the objection at that time.
So the court is not going to conduct a proffer?
I don't, I'm taking what the counsel is saying. The proffer would only be as to what his opinion is the effects of these amounts of THC in a person's blood, what effect that would have, for whatever it's worth. Next two we have are the state's motion in limine regarding Mr. Root and the animation. Do you want to do the one regarding Mr. Root first? I've read the motion, and basically I know what the state's argument is going to be, and I have to, I have to ask what the defense would offer. That this court's already made a similar ruling, and that was in not allowing the detectives in the case to offer their opinion as to what happened during these events, that was improper. What would be the difference with Mr. Root?
First, I think what the court did sort of in a global sense was not allow law enforcement to come in and say, I don't believe that probable cause existed for the arrest.
And the motion in limine, and you can correct if I'm under the wrong assumption, but in the motion in limine filed by the state, it indicates that Mr. Root is a former law enforcement officer, and he's basically an expert witness in law enforcement, and that he's going to testify that the defendant did not violate any Florida rules or statutes, that he acted in self-defense. I mean, if that's where you... Basically, is that what you're asking him to come in and testify to? As to his opinion as to what happened during an incident that he was not there to witness?
There are a couple of categories of testimony I would elicit from him.
Okay.
That one that you just mentioned may be the most problematic for the court, but there are other testimonies, which is his view of force events, and how you look at reasonable abilities or relative abilities of the two parties, and how that is one element to consider, and his expertise both from a use of force perspective, from a law enforcement perspective, from a training perspective. So that's another issue that he'd be looking at. He would also be looking at the effects of trauma on a person. He's, of course, been involved in a number of police shootings, and has had a lot of both experience with police shootings and the effects on police and some of the safeguards and procedures that are put in place with police officer shootings, the effect that has on the shooter, the effect that trauma has on an individual who suffers it, and how that might affect their ability to testify and remember events. So there are a number of areas in which Mr. Root has a great deal of both experiential and training experience and testifying experience, though not an enormous amount because he's new off of the active law enforcement ranks. But it is in some of those areas that I intend to have him. He's viewed all of the evidence, literally all of the evidence, so he has a good background factually as to what happened. Relied much more on other witnesses' statements of what they perceived, what they saw, of course, medical records, reviewed my client's statements that are now part of the evidence, spent very little time and virtually no substantive time with my client regarding the event, so that all of his testimony would be only on the evidence which is now before the jury, and would be able to sort of present to the jury in an expert perspective information that he is personally or professionally aware of from an expert perspective, which may assist the jury. Just as we bring in any other expert, we can make believe that...
Aren't those common sense issues for the jury to make a determination on their own?
No, I don't believe that this jury has much of an idea as to how a law enforcement officer and any other person reacts to a traumatic event, that traumatic event being getting beat up and having to shoot somebody. I don't think that this jury has the experience background to talk about what relative physical abilities are, which is one thing that they are required to consider under the jury instructions. And just as we could say that the jury could consider what it's like to be under 1.5 nanograms of pot, the state is suggesting that we not allow them to make such an assumption, that we bring forth expert evidence before we bring this evidence before the jury. In like ways, we have an expert who can tell this jury about the effects of an event on a person's ability to remember, to recount, and to discuss properly. And while, again, it may be somewhat problematic to have him come in and testify that based upon his review of all the entirety of the circumstances, that Mr. Zimmerman acted reasonably in reasonable fear of great bodily injury. If the court were to limit that, I would understand. But there are a great deal of his information, most of his information that he can impart to the jury would not be talking about ultimate fact issues. And let's not forget that ultimate fact issues are not per se improper. It's just that you can't invade the province of a jury while doing so.
Okay, thank you. Please argue, Mr. Guy.
Thank you, Judge. Judge, the motion in limine is relatively narrowly tailored to the three opinions that he offered in his deposition. I think I deposed him for 2.5 hours a week ago Saturday, and this is what he said his three opinions were. Those are not proper for a jury, as the court has already noted based on the case law cited in the motion. As to his other facts or opinions, I suppose we will make objections at the time as to their relevance, understanding that he may understand how law enforcement officers or other people might react to a situation, but I don't know how he's going to testify how this defendant reacted, not having been there and not having known the defendant prior to the murder of Trayvon Martin. So as to the other elements of his testimony mentioned by defense counsel, I'll make objections at the right time. But again, the limine motion is relatively narrowly tailored to the three opinions offered in his deposition. I ask the court to grant that, as all of them speak directly to his the defendant's guilt or innocence, and therefore would be improper.
Okay, any response?
Just that I would proffer to the court, because I think it's going to be necessary for the court to review it before making determination. We do have a copy of the transcript of his deposition. It did run 2.5 hours or so, but it outlines not only his opinions in well-formatted categories so that you could see my argument, even if it's not as artful as it was presented in a 2.5-hour deposition, and also gives a good foundation so that as you're determining whether or not to allow it, you can sort of see the basis for his foundation, both from an evidentiary standpoint and from his experience standpoint. So I guess I'm asking you to take the time maybe tonight to review the deposition before making a decision on that, because it might assist you in crafting whatever order you might have.
Okay. Thank you. I don't need to read it for that purpose. The state's motion is very clear as to specific opinions that he may have. And the court finds that allowing Mr. Root to testify as an expert would be bolstering the credibility of the defendant from his statements, which is improper, and it would also introduce self-serving statements which are otherwise inadmissible hearsay. And that would be the state's motion in limine is granted that Mr. Root cannot testify that the defendant, Mr. Zimmerman, was reasonable in his use of deadly force against Trayvon Martin. Second, the defendant did not violate any Florida statutes in his use of force against Trayvon Martin. And third, that the defendant exhibited restraint before using force, a deadly force against Trayvon Martin. Those are the areas in which he will not be allowed to testify. That leaves us with the animation.
As to the admission, I think the state's motion will make sure that we're arguing on the same point, because in response I don't want to steal your thunder. In response to objections that we've gone back and forth, the animation has now been limited in great fashion. I'm not sure we can call it an animation anymore, but I guess there is some moving parts to it before it goes to still frames. So
Well, let me ask you a question. Is this being sought to be introduced as an exhibit or for use as a demonstrative
as an exhibit, Your Honor?
to be introduced into evidence?
Yes.
Okay, well then do we have to have a Daubert hearing?
I probably.
Well, call your first witness.
Now, I think the newest version of the animation was given to me about 3 hours ago. It is significantly different than the last version, but I still maintain some of the objections.
I'm wondering, Your Honor,
This was noticed for hearing for this evening, so I'm ready to go.
okay, I'm not certain that I am right now, but I'm wondering if maybe even with a 5 to 10 minute break, I just want to be able to focus the state's objections because we've attempted to address some of them by limiting the animation nature of the exhibit. So I'm just,
Okay, well, if it's an animation for demonstrative purposes, then Daubert would not apply. But if it's being sought to be introduced into evidence, I think that there it requires a Daubert hearing. If it were before July 1st, it would have been a Fry hearing, but now that's changed. So we will take a recess for 15 minutes to give you an opportunity to discuss with the state if there's still objections to it. Before we do that, could counsel approach for one moment?